You're watching The Legal Breakdown. So we've got some major news here. Donald Trump's jury intimidation is already backfiring on him at trial. But first, just a reminder to those viewers watching right now that Glenn and I will be doing comprehensive coverage of the entirety of Trump's trial. So if you want to follow along with daily updates, please make sure to subscribe. The link's right here on the screen. It's also in the post description of this video. Okay, so Glenn, a jury member who was already selected and sworn in bailed today because she was worried about her identity being leaked. This immediately after Trump had taken to Truth Social and accused the jury of being liberal activists who were just, figuring out a way to get on the jury so that they could rule against him. Is this jury intimidation by Trump, and is it yet another violation of his gag order?
We will know soon enough, because that will be a decision for Judge Merchan to make. But right now, Brian, the magic number is 7. There are 7 contempt allegations that the prosecutors have offered to Judge Merchan and said he needs to be punished. He needs to be sanctioned because no less than 7 times, and I think they were being generous there, he has violated the court's gag order by saying something or posting something about witnesses or about jurors that he shouldn't be saying or posting. So on Tuesday morning, Judge Merchan is going to take up what I think is a hugely consequential motion. The prosecutors seeking to hold Donald Trump, or have the judge hold Donald Trump in criminal contempt. Donald Trump has got a lot of firsts under his belt. First former president indicted in state court. First former president indicted in federal court. First former president to be held in civil contempt multiple times in his New York fraud trial. And I think he's on the verge of being the first former president to be held in criminal contempt. The question becomes, assuming Judge Merchan holds him in criminal contempt, and I believe he will, what's the sanction? What I can tell you, Brian, is it's not that unusual for defendants to violate court orders. What ordinarily happens is the judge on the first violation will give the defendant a stern talking to and say, do it again, you're going to be fined. If they do it again, they are fined. And almost every time during that second contempt hearing, the judge will say, do it a third time, you're in jail. And I think we are already past the stern warning part, because Donald Trump has been sternly warned over and over again, and he keeps violating Judge Merchan's gag order. So I think what we're going to see on Tuesday morning is Donald Trump being held in multiple counts of criminal contempt, sanctioned probably to the maximum $1,000 per violation. But the other sanction is up to 30 days in jail for each violation of a court order. I think you're going to hear Judge Merchan say on Tuesday, one more time, Defendant Trump, I'm ordering you into a jail cell. At least I hope he puts Donald Trump on that kind of direct notice. And I think there's a very good chance that as this trial progresses, we're going to see Donald Trump go from a free man to an incarcerated defendant.
Glenn, I have a feeling that Donald Trump views everything that's happening before this show cause hearing on Tuesday as strike 2. So it's just, he keeps committing these violations. It's strike 2, strike 2, strike 2, strike 2, knowing that until he gets that final warning from Judge Merchan, basically saying that this is it, that was strike 1, that was strike 2, next time you do it, you're going to jail for 30 days. Why wouldn't Judge Merchan just move up that show cause hearing basically from Tuesday up to today so that he doesn't get this long runway to commit these violations, on an exponential basis until the hearing actually happens?
Great question. And I really do think it's because of the New York state law. There are 2 kinds of contempt. There is contempt that happens in the presence of the court. The judge sees it. Donald Trump says or does something that violates a court order. And then it's like in the movies, the judge bangs the gavel and can summarily hold the defendant in contempt right then and there, and can issue a sanction up to and including 30 days in jail. However, if the contempt does not occur in the presence of the judge, in the courtroom, then the New York law provides you have to be given notice that there will be a hearing on the contempt charge, and you have to be given an opportunity to defend yourself. That is why I believe Judge Merchan set it off for about a week from when the first request came in from the prosecutors. Now, of course, Donald Trump is just racking up additional contempt charges. As I say, we're up to 7 right now. But but I think that's why Judge Merchan is sticking with that Tuesday contempt hearing date, because under the laws of New York, the defendant is entitled to notice and an opportunity to defend.
And when you say notice, does that mean that he needs a certain amount of time to be able to prepare? Because otherwise I would ask, like, how does the judge not see the danger in allowing Donald Trump the full weekend to keep racking up these violations, knowing that it's all going to be chalked up to, just a $1,000 fine each time before he's given an actual warning about jail time, which would actually prevent him from doing any of this?
Yeah, great question. The New York state law uses the word notice. It does not set a time frame or a deadline. So I think Judge Merchan assessed that giving him about, 6 days, which was from the time the prosecutors first moved to have Donald Trump held in contempt, was appropriate notice. But he could very well have said, listen, we're going to carve out some time on Friday and we're going to take this up because you can't be trusted not to continue to violate my gag order over the weekend, or not to continue to say and do things that are intimidating jurors, which Judge Merchan ordered Donald Trump in open court not to intimidate jurors. Because Donald Trump said or did something, it wasn't precisely reported what he said or did, but he did something that was directed at the jurors, and instantly Judge Merchan said, I will not have juror intimidation in my courtroom. So Judge Merchan perceived it as juror intimidation and put Donald Trump on notice that he wouldn't stand for it. So if there is additional juror intimidation, those will probably constitute additional contempt charges.
Additional contempt charges, but are we likely, or is it still possible that we could see this show cause hearing moved up if Donald Trump does something that's so egregious that Judge Merchan recognizes, okay, if I give this guy another day, hour, minute, without this show cause hearing actually happening, then, he can just cause too much damage?
Possible. I would say not likely, but
Okay.
Possible, depending on the nature of the intimidation, the harassment, the threats. Because, if we have jurors that are sort of concretely put in harm's way and the judge gets wind of it, he could absolutely just move the contempt hearing up and saying, listen, you can't be trusted. We have to do this right now.
Now, I had mentioned at the top of this video that Donald Trump's efforts to violate this gag order does seem to be backfiring on him to a degree. So I want to turn your attention to a tweet from Kyle Griffin at MSNBC. Trump attorney Todd Blanche asked who the DA's office plans to call as their first 3 witnesses. Joshua Steinglass from the office refused on the basis that Trump has been tweeting about them. Judge Merchan said he doesn't blame the DA's office. Blanche said that Trump won't tweet about the witnesses, to which Merchan said Blanche can't promise that. Merchan refused to order the DA's office to name its first 3 witnesses. So, again, this is already seeming to backfire on Donald Trump. What's your reaction to that?
So, let me tell you how we usually do business when we're in trial. As a courtesy, I will give the defense attorneys notice of, for example, we call it our order of call, the order in which we're going to call our witnesses to the stand. I will give them the order of call for the next trial day as a courtesy. Why? Well, because that way they'll know what boxes to bring, what files to bring, and it does give them a little bit of time to prepare the cross-examination of those witnesses. But it typically makes the trial go a little bit more smoothly if the defense team is on notice of who the trial witnesses are for the following day. The prosecutor said, you're not getting a single name because you can't be trusted. What do you think Donald Trump would do if he had the names of the first 3 witnesses who are going to testify against him in his first criminal trial?
It would be nonstop character assassination on the entire Fox News rundown, on Daily Caller, on every single facet of right-wing media.
To use Donald Trump's word, it would be a bloodbath. So not only did the prosecutors say, Judge, we're not going to do it, we're not going to endanger the witnesses like that, Judge Merchan said, I'm not going to order you to do it because you have a point. So the reality is Donald Trump's defense team will have to schlep every single box and witness file to the courtroom. Why? Because this is a problem of their client's making, because he can't be trusted not to violate the gag order, not to endanger the witnesses if he knows these are the witnesses who are about to appear on the stand and give what is likely to be sharply incriminating, even damning testimony against Trump. So this is a real departure from the normal course of business. But you know what, Brian, when I prosecuted some of the most violent offenders in the District of Columbia, I would also take this precaution. But it was really only in those cases. And let me add, this is an anonymous jury, right? I only had 2 anonymous juries in my entire 30 years as a prosecutor, and those 2 juries were in cases against the most violent RICO organization that we ever tried in federal district court in Washington, D.C. The Washington Post dubbed them Murder, Inc., Murder Incorporated, because that RICO enterprise killed 31 people. They were supremely dangerous. They posed a real danger to the jurors and the witnesses and the prosecutors and everybody else. And they were so dangerous that the judge decided the jurors had to be anonymous. Think about that. That is the case that can be used as a measuring stick for how dangerous Donald Trump is to the jurors and everybody else in this process.
Yeah, you just add today's Trump Republican Party up there with a RICO conspiracy organization that was dubbed Murder, Inc. I mean, how sad is that? Glenn, Trump's goal here was obviously to signal to his acolytes, be it in the media or just elsewhere in the party, that he wants to sow doubt in the integrity of this jury, even if he does comply with the gag order moving forward. So is there going to be anything that the judge can do to protect the integrity of this trial from the Jesse Waters of the world, for example? Or is it just like, look, everybody else has free speech, nobody else is gagged in the same way that Donald Trump is, and so now that he sent his clarion call out to his to his acolytes, to his mouthpieces, they're just gonna run with it?
Yeah, the answer is Judge Merchan can't control or prohibit, the faux news networks or Donald Trump's flunkies and acolytes and mouthpieces. He can't order them not to post things about witnesses or jurors, but what he has done is he's taken an additional step to protect the identity of the jurors by basically scrubbing from the record all information about, for example, where they work. Because, in this day and age, it doesn't take much to identify a witness who, if you get enough information about where they live, not their address, but several witnesses said, I've lived in, X neighborhood for the last 40 years. Right. What they do. One of the jurors said she was an oncology nurse at one of the major New York hospitals, and that is actually one of the jurors who said she could sit fairly on day 1, and then on day 2 she came back in and said, you know what, I'm being hounded now. It looks like people have identified me, and I want out, and the judge let her out. She's excused, and another juror was selected to replace her. So, but the judge can only do what he can do. And what he has done is choose to restrict even further the amount of information that the public, anybody, gets to know about who these jurors are.
And finally, let's end with this. We now have 12 jurors who were selected and sworn in. Talk about where we are in the process, what still has to happen from this point on.
Yeah, it actually ended up being a very swift jury selection. In less than 3 days, they had 12 jurors seated. They're still in the process of selecting the 6 alternates. But I think that's really a tribute to the unorthodox jury selection process that Judge Merchan followed. He let every juror opt out by simply saying, I don't think I can be fair. He dismissed them, didn't ask them any questions, didn't try to probe what the basis was for them saying they couldn't be fair. So because everybody who thought they couldn't be fair was allowed to leave, the batch of jurors that they did question, had already sort of said, I think I can be fair, and then they probed that some more. So within less than 3 trial days, we had 12 jurors qualified and in the box. So now the projection is that by Monday, they'll be ready to go to opening statements. I think the trial may progress a little bit more quickly than people anticipate. So we could see the government presenting all of its evidence within the first week or 2. Then the case will be turned over to the defense. I suspect they will not have many witnesses to call in Donald Trump's defense. So we could actually see a verdict in this case, I think, much quicker than we originally anticipated, like perhaps within 4 weeks.
Okay. Quick question on the amount of alternates. Given the turnover that we've seen thus far already, is it not unusual that there would only be 6 alternates, or does it have to be 6? There's always 12 plus 6 alternates. And I ask because, we've seen a little bit of turnover thus far. We had 2 jurors who had been sworn in previously who had dropped out, and you never know what can happen in such a high-profile trial like this. So why not pad the numbers a little bit with a few more alternates?
6 is far more alternates than usually are seated in a case. Usually it's 12 jurors and 2 alternates in the run-of-the-mill jury trial. Let me give you an example. I had a 6-month-long RICO trial. We started with 12 regular jurors and 6 alternates. And even during the course of our trial, Brian, with the anonymous jury that I was talking about earlier, some of our defendants still managed to get to some of the jurors. And during the course of the trial, we had to dismiss a couple of jurors and replace them with the alternates. But I actually think 6 is probably enough to get through what will end up being about a 4-week trial, although I recognize that it's a highly unusual 4-week trial because the defendant has been almost given carte blanche to say and do anything he wants to endanger witnesses, jurors, prosecutors, judges, and their staff and family members. So, your observation, I think, is an important one. What's the harm in having even more alternates, anticipating Donald Trump will still continue to do his nefarious best to try to interfere with the due administration of justice?
Glenn, just a real quick question here. How does a jury sit for 6 months? Like, how do you keep your job if you don't show up for 6 months? How do you get paid? How do you support your family? How do you show up for weddings and bar mitzvahs and birthdays? Like, how does that work when you're sitting on a jury for 6 months?
Yeah, that's a great question. So what we do is when we go through jury selection, we let the jurors know this is going to be a 6-month commitment. What ends up happening? We actually end up getting, for example, in Washington, D.C., lots and lots of government employees because their employer, the federal government or the D.C. city government, can never sort of punish them or retaliate against them for going absent for 6 months because they have been selected to serve on a jury. So you also get a lot of folks who maybe were not gainfully employed in the first place. Maybe they were on a sabbatical from work. And the other thing is, you get people who are not sort of wage earners or who are on contracts such that if they're not churning out the work every day, they're not getting paid. The last thing we want to do is cause a financial hardship for somebody. One of the questions the judges will ask of those jurors is, listen, would it present a financial hardship to you and your family if you were to sit as a juror for 6 months? And when those jurors said, I couldn't make ends meet, I couldn't pay my rent, we instantly excuse them because we don't want that to inure to anybody's financial detriment. But we end up getting a lot of government employees, particularly on D.C. juries, or people who are otherwise maybe retired, or maybe it's the school year, but the trial is in the summer if it's a 2-3 month trial. So, yeah, we try to catch as catch can the kind of jurors whose lives would not be, frankly, devastated if they were made to sit in court for 6 months.
All right, well, super interesting stuff. Of course, for those watching right now, Glenn and I will continue to cover the entirety of this trial. So if you want to follow along with everything that happens as it happens, please make sure to subscribe. Again, the links to both of our channels are right here on the screen. So just go ahead and hover over both of those links. Make sure to hit the subscribe button, and we will continue to follow along with everything. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.